I think there we go. We've got a little red dot in the top corner, so there we are. Okay. So one final thing just before I pass you over as well. The British Chamber of Commerce has just released its quarterly economic survey. I will put a link in the chat box to the slide shortly. It's just really important that we get as many people to fill in that survey so we can best represent you as an area going forwards. I'll put that link there for you in a second. And just as a little incentive, there is a chance to win a Apple iWatch for anyone that completes the survey. So that's it for myself and the Chamber team. I'm going to pass you across to Paul Hennity, who's going to introduce his team there. And yeah, take it away, Paul.
Thanks very much, Louis. Yeah, that's right. I'm Paul Hennity, and I'm an associate in the employment team at Aaron & Partners. Pleased to be joined today by a few of my colleagues. Steve Davis will be answering questions along with me from one of our colleagues, Helen Johnson, who's going to be asking questions which have been submitted by a number of different businesses over the last week or so. We're also joined by Michael Redston, who's going to be answering questions on the live chat feed. So if anyone's got any sort of specific questions within reason, they can put them in the chat box, and Michael will do his best to answer those as we go along. And finally, Victoria Sivert, who works in the family team at Aaron's, and she's going to answer some questions at the end about sort of the personal consequences of coronavirus and the impact it's had on family law. So, obviously, coronavirus is something that's massively affected business across the UK and of course the world. And I don't think there's any business really that can say that it's not been affected at all by coronavirus. For employment lawyers, it's been a fairly hectic and certainly an interesting time. Personally, I didn't even know what furlough was at the end of February this year. So it's been a very, very quick learning curve for our team and obviously our firm as well. We've also all had to quickly adapt to working from home and things like that. In terms of what we're going to look at today, obviously the topic is furlough and coronavirus and the job retention scheme. I took the view that most businesses who would be on the call and would be wanting information would actually have probably already taken advantage of the coronavirus job retention scheme, which, as you know, was introduced in early March. So the plan really is to sort of briefly touch on the eligibility for the scheme, but now is actually to look forwards and see how it's going to affect as consequence and the consequences of coronavirus moving forward, and hopefully give you some good tips to try and cope with the situation and hopefully come out the best you possibly can for it. So Helen's going to ask the question. So I think Steve's got the first question. So Helen, if you're ready to.
Okay, thanks, Paul. Okay, Steve, to you first then. Most people who are going to take advantage of the furlough scheme have now done so. But for anyone still looking at using it, could you please give us a brief update on the qualification requirements? And have you had any feedback on the scheme from employers or employees?
Yes, sure. As Paul mentioned there, as most people are now aware, the furlough scheme or the job retention scheme, whatever you want to call it, is a temporary scheme whereby HMRC will reimburse 80% of an employee's wages up to a maximum of £2,500 a month. To be eligible, both the employer and the employee must agree must agree for the furlough. And once it has been agreed, the employer is also then required to write to the employee confirming that they have been placed on furlough. It's open to any employer in the UK which has a UK payroll, a UK bank account. The employee must have been employed on the 19th of March 2020 and on the employer's PAYE payroll before the 19th of March, so before the 19th of March 2020. The scheme is available for employees. It's also available for workers, so people on 0 hours contracts, but it's not available for self-employed people, subcontractors, and the like. I think you asked as well about feedback. I think that's been quite positive. I've spoken to clients on both the employer and employee sides, and I'm not aware of any problems with the scheme. I think the payments are going through. I think the process is fairly straightforward. There might have been some teething issues when the portal first opened up, but any teething problems that were there, I think have now been remedied. So I think it's, touch wood, seems to be going quite well at the moment.
Okay, great. Paul, looking at vulnerable employees, how do employers continue to deal with vulnerable employees or those who have vulnerable relatives at home?
Yeah, so obviously initially sort of the panic created by coronavirus, a lot of people didn't feel it was safe to go to work. And once lockdown commenced, they either felt that either because they themselves have got something that means that they might be more exposed to either contracting, or that if they do get it, the consequences will be much more serious, that they didn't want to go to work. And the other one, of course, as you mentioned, is that those who've got children who might be ill or disabled, or family members who might be suffering with cancer or something like that, or indeed elderly relatives that they may live with, and they're worried that by them going to work they could contract coronavirus, bring it back to the family home, and then pass it on to people who are vulnerable. This was a big headache at the start, and there was, as I'm sure you'll appreciate, much of the advice around the job retention scheme has sort of evolved over the months. However, the position regarding with the vulnerable employees themselves is really that now they can, and it's being clarified, it was clarified eventually, that they can choose if they want to self-isolate, and they can stay at home, and they can get a note or a letter from the NHS to say that they're self-isolating, and that does now entitle them to sick pay, statutory sick pay, and the company is obliged to pay sick pay if they choose to self-isolate. If, however, it's not them who's sick, well, the employer really can take quite a hard line. They can say, "I'm sorry, if ultimately it's your choice. If you don't want to come to work, then it's an option of taking some holiday, or indeed just unpaid leave." Obviously, quite quickly after that, those concerns raised, we got furlough, so it was an opportunity for some employers to say, well, we'd like to take advantage of the furlough scheme and therefore put those vulnerable people on furlough. But if that was not an option, then really the benchmark position is unpaid leave or holiday. Of course, there's always a caveat, and with employment law, we always have to be conscious of disability and potential discrimination. So if you also make sure that you actually are factoring in considerations for reasonable adjustments or whatever, and if you were putting someone at specific risk by making them come in, or giving them the option of no pay, well then it could be discrimination. So just make sure you think carefully about that if you are dealing with a disabled employee. Okay. Thank
you. Steve, employees on furlough, what work is it possible to ask them to do? For an example, if there was an emergency, or the employer needs to ask a quick question which can't be answered by anybody else?
Yeah, well, I think I'll start with just briefly reading what the guidance states on that. It says, to be eligible for the grant when on furlough, an employee cannot undertake work for or on behalf of the organisation or any linked or associated organisation. So this includes providing services or generating revenue. So it's open to interpretation, but I think it's pretty clear that you can't do any work that you would normally do as part of your day-to-day process, because you would risk losing eligibility for the scheme. But in our view, I think asking quick questions, asking employees for the whereabouts of a file or something like that, that probably isn't providing services, and it certainly isn't generating income. So I think for those sorts of things, perhaps in an emergency, provided they're not generating an income or doing actual work that they'd normally do, I think you should be okay. Just be careful in how you interpret that guidance, and you use common sense. But certainly for emergencies and asking questions, I think that should be fine. But it's a little bit of a grey area, so do obviously. Yeah, just to follow up there, Steve, I think if the employee has been off for 3 weeks already, then the employer could actually, if the employee was prepared to agree and say, actually, could you come in on Wednesday and do a full day's work? We'll pay you 100%. We can't claim that day's back.
and then put you on furlough again on Thursday. There's nothing wrong with doing that, provided the employee is prepared to agree. So that is one option if you sort of needed things doing and you're prepared and in a position to pay.
Yeah, absolutely. I think the only risk, if it's within the 3 weeks, just being careful not to bring
It'd have to be more than 3 weeks.
Bring it to an end, that's all. But certainly after the period of 3 weeks, yes.
Thanks. Paul, you mentioned pay there. If an employee has been placed on furlough and the employer has been topping up to full pay, can the employer now reduce their contribution if they want to?
So some employers at the start decided that they would pay 100% of wages and they would claim back only 80% of the government, obviously including the cap of 2,500. So if you had taken that decision to pay it 100%, then basically you're not bound. You're only bound by that up till the period that you've agreed to do it, or to some point where you basically have to say to the employees, look, we're no longer able because of the length of time this is going on. I mean, the government have already indicated that furlough is going to be available to October, but from 28th of February to the end of October is 8 months. So employers might have been able to be generous initially, but may not be able to be as generous now or moving forward. So I would certainly, I think the way you would have to do it is sort of write to them, explain the reasons why you're going to have to go down to the 80% or work within that 2,500 limit, and ask them to agree. Now, most employees, to be fair, we've found have been pretty receptive rather to the coronavirus job retention scheme, and have been happy to be furloughed. I think the idea that you will get 80% of your wages for doing no work, and actually at the moment we can't really spend any money anyway, probably isn't that bad a deal. So I think most people have just been accepting, and obviously accepting of the bigger situation that we are, trying to reduce the burden on the National Health Service and obviously all stay safe. So that's what you do. It would just be an informing and consulting process with those employees and getting them to try and agree, really.
Thank you. Steve, question on key workers. Are construction and manufacturing workers now classed as key workers, meaning their children can go to school so they can go to work?
I think the short answer to that is no. As far as I'm aware, there has been no change by the government to the definition of key workers. I think in the government announcements, what was stated is that all workers, and I think construction and manufacturing workers were particularly highlighted, were actively encouraged to return to work if they couldn't work from home. But there was nothing in the guidance that I could see which did class them as key workers in the same way as nurses, doctors, and the like. But like I say, they did encourage all workers to return to work if they can't work from home, and the specific emphasis was put on manufacturing and construction workers.
Thank you. Related to that, Paul, what are the options that we have as employers if your employee says they can't return to work because of childcare commitments?
Yeah, so again, this is a practical problem which has really been aggravated, obviously, by the closure of the schools. So most people's main source of childcare is schools because the children are at school and they are able to go to work whilst they're at school. So I think in terms of what the options available, well, again, if they're not on furlough and they say, well, I've got to look after my children, then again, it's back to a similar situation with vulnerable relatives. It's unpaid leave or holiday. Obviously, as I say, the other option is furloughing them. So yeah, we can think about emergency dependent leave, which is something which is usually taken when a child is sick and the parent has to stay at home to look after the child. That can be paid or unpaid, depending on arrangements with the employer. But really, that's not applicable to this situation because we don't really work very often in an environment where the schools are closed for such long periods. It's usually, I say, for an unexpected day's absence or a couple of days' absence, whereas this is a longer period, and so dependent leave really doesn't come into this. So I think really you'd have to ask them to take holiday or just no pay.
Okay, thank you. Okay, moving on to redundancy, and first question to Steve. Unfortunately, some businesses may be having to consider redundancy. How should they approach this? And what about
Well, I think
take
obviously the first thing to say is that the furlough scheme remains an option. The government is clearly encouraging employers to use this scheme. It's designed to help employers to avoid redundancies. But obviously, for some employers, redundancies are going to be unavoidable. And in that situation, the employer would still need to demonstrate that the employee's job no longer exists. So an employer would still need to go through its usual redundancy procedure. So there must be a genuine redundancy situation, for example, a closure of the business, closure of the place of work where the employee works, or a diminishing need for an employee to do work of a particular kind. They must also consult individually with that employee still. Nothing changes there. They've got to go through a fair selection process still, so common ones using a skills matrix, and also offer any suitable alternative employment that might be there as well. So you still have to go through a fair redundancy process. If there's 20 or more employees at a single establishment, so one unit, for example, that you are wanting to make redundant, then collective consultation kicks in as well. Now, that can take time. If it's between 20 and 99 employees that you are making redundant, you've got to make room for 30 days worth of consultation there. If it's more than 100, you have to make room for 45 days consultation. So it's important to bear those in mind. A failure to consult collectively can result in a protective award for each individual employee for up to 13 weeks pay. So it's very, very important that you still get that process correctly. There's a risk that the employee might also argue that the fact that there is a furlough scheme available, that this in itself means that the redundancy is unfair.
Can you start a redundancy, Paul? Can you start a redundancy process or consultation to reduce hours while staff are furloughed?
Yeah, so again, a lot of employers are now looking at the future, and I think redundancy is unfortunately something that's being contemplated, and a lot of people are wanting to know whether they can actually start that consultation while staff are on furlough. Our view is that there is no reason why they can't, and we don't think sort of attending any sort of meetings in terms of redundancy consultation with the staff would actually bring an end to the furlough, so and put at risk the ability to claim back the 80%. So I think absolutely yes, if you think consultation is necessary, then we think you can do it. Now, obviously, most redundancy consultations involve face-to-face meetings. So really, I think the way it would have to be done is correspondence, well, most correspondence now is dealt with via email, so we don't see any issue with that anyway. But again, I think if you were doing Zoom meetings or FaceTime or whatever is appropriate, whatever tool that you're using, I don't see any reason why that wouldn't be acceptable. I have heard some rumours or feedback from clients that the trade unions are very reluctant to want to engage in collective consultation over Zoom, FaceTime, or whatever. Whether they are being deliberately awkward there, I don't know, but that is one potential objection that some people have, saying they don't want to engage. But I think if it's absolutely necessary to the business, I don't really think it would be deemed to be unreasonable. The other question is, of course, relating to notice. So once you decide that an employee is redundant, obviously that employee is then entitled to their notice, whether it's statutory or contractual. Our view is that you would have to pay notice at 100% of the normal pay. So, but the question that we don't really know the answer to at the moment, and there is real lack of clarity on, is whether you can claim back 80% of notice pay. So, whether you can technically, are you using the furlough scheme to sort of help pay the notice? Now, my concern with that would be, well, this is literally called a coronavirus job retention scheme. So using a job retention scheme to sort of terminate someone's employment and use the payments for that may not sit well with HMRC. But to be honest, the honest answer is at the moment we don't know what the position with notice is, apart from the fact, our view is that you should pay at 100% of normal pay, not reduced 80%.
Thank you. Steve, looking at sort of more standard HR procedures, can employers still conduct formal hearings such as ill health or performance capability meetings, disciplinaries, grievance hearings, etc., while staff are on furlough?
Yeah, I think Paul's answered this really in relation to redundancy, and I think that the answer is yes, and I'd add to that things like PDPs as well. However, I would say that I think employees that are participating must be participating out of their own choice, and I think any process procedures must take place in line with current public health guidance, so social distancing and things like that. I think it's. I would actively encourage clients where possible to do it by way of video conference, such as this forum here, Skype, WhatsApp, anything like that. I think that would certainly help employers adhere to current public guidance. Obviously, make sure with all of those participating within the process that they do have access to that technology in the first instance, and if any documents are going to be shared, that it can be seen, all parties can see the documents clearly. There might be issues of confidentiality when talking about documents like that as well, but provided employers are careful and the employees are happy to participate in that, then I think it should be absolutely fine. Yes.
Thank you. Paul, if an employee has been furloughed or put into a shorter working week due to COVID-19, how is their redundancy pay calculated?
Again, our view is that it would be based on normal pay, so normal length of service, and the usual calculation relating to age and how much they earn, currently capped at £538 a week. Most short or reduced hours have been agreed on a temporary basis whilst coronavirus is affecting business, and with a view to coming back full-time once it's all over. So the short answer to that is pretty much just the redundancy pay that they would have been entitled to prior to the furlough or the agreed temporary change to the working hours. Obviously, if they'd agreed a permanent change to reduce their hours because they wanted to and it suited them despite of coronavirus, then arguably the redundancy would be low. But if it is purely because of coronavirus, and they wouldn't have done it otherwise, and I think really the redundancy should be based on the ordinary pay.
Thank you. Some questions coming through on the chat actually about holidays now. I think we should be covering them off. Steve, holiday pay on furlough. Some employers are still unsure on the situation regarding holidays. Could you clarify what the situation is about asking employees to take holidays and what can be claimed back from HMRC?
Yeah, sure. I think obviously employers want to avoid the situation whereby when things come back to normal and employees are back into the workplace, they don't then all of a sudden take all of their holidays at once. So I think there's been quite a big debate between employment law circles on this very issue since the scheme commenced. I think the short answer is yes. Generally, employers can require employees to take holiday, provided they give them twice as much notice as the amount of time that they want the employee to take off. So, for example, if they want the employee to take 2 weeks off, then they would be required to give them 4 weeks notice in the first instance. That said, I think forcing employees to take holidays does not come without risks. The idea of taking a holiday is to allow employees to rest and recuperate, take place in leisure activities and things like that. So it's probably worth having a discussion with the employee to make sure that they are able to rest and relax and take part in leisure activities. Obviously, during a lockdown like this, they won't be able to take summer holidays abroad and things like this, which might upset some employees. So I think the safest option would be to try and get the employees' agreements. But I think the short answer is yes, but just be aware of the risks. In relation to what the company, the employer can claim back from HMRC, the latest guidelines outline that the employers should top up the holiday pay to 100%. So the employee should not be at a disadvantage for taking the holiday, and the employer can then make a claim back, I believe, for the 80% in the normal way as they do for normal salary.
Okay, thank you. That's some response to those who are on furlough. Paul, what about if employees are on furlough and not taking their holidays? What happens there?
Yeah, so I say Steve and I and the rest of the team were pretty delighted when we got our got the actual notes from the government on the government website confirming that the advice that we've been given on holidays was more or less correct. So we were really there was clarity on that. So the position with holidays and carryover is that in the UK we have 5.6 weeks holiday, so that's usually 28 days. That's actually broken into two parts: 4 weeks and 1.6 weeks. 1.6 can be carried over, and the 4 weeks can't. However, because of coronavirus, and as Steve mentioned, the worry for most employers is, oh, I've been off now for 6 months on furlough, and then they come back and say, right, I'm going to take 6 months worth of annual leave. Thank you very much, and I'll have full pay for that. So, not ideal for businesses who are wanting to get back up and running and back to normal quickly. So the government have passed emergency legislation now to say that those holidays can all be carried over for up to 2 years. So if you are worried about the holiday situation, I would probably, if you've got a lot of staff off and you're worried about them accruing holidays, I would probably be thinking about making them take holiday. Even if it's just a week, it's going to reduce your liabilities, and you obviously can take advantage of the 80% claim back. So I do think really it's a good idea, and if anyone needs any help with that, we can assist. The other point, sorry, just lost my train of thought. I think that's it. I would just reiterate that you should encourage them to take the holidays again. That was what I was going to say. If you're not going to make them do it, or even if you are, really start thinking about planning for the next 2 years and how you're going to, structure the holidays, when people are going to take them. Are you going to make them, maybe not make them take them whilst coronavirus is impacting us, or whilst they're on furlough, but when are they going to have to take them? Because obviously over that period they will be continuing to accrue more holiday. So really you should be thinking about your plans for holidays and when people should be taking them.
Thank you. On holidays, as rumours abound as to what's happening with the rest of the world and the airline industry getting going again, is it possible to place restrictions on where people go on holiday if it means they will be quarantined when they get back? So anywhere other than France, I think.
Yeah. I mean, I don't think really anyone can go anywhere on holiday at the moment. So probably at the moment not an issue. But as the restrictions relax and hopefully flights start moving again, and people want to go abroad, the problem may well be that if you go to Spain, you might end up having to spend for 2 weeks. You might have to, when you come back to the UK, you might have to spend 2 weeks in quarantine here. Well, what that may mean for the employer, of course, is that they're off for 4 weeks. That's not going to be great for the employer. Not great for the employer, potentially great for the employee, but the consequence really is they might not get paid for those second 2 weeks if they were taken as annual leave. I think really, obviously and hopefully employees are going to be sensible about where they go, and I think you should try and have sensible conversations with them if they are thinking of going abroad and it's going to result in quarantine. Have to be a little bit careful about saying what people can and can't do on holiday, and as Steve said, it's important that they have the opportunity to relax, but I think really it would not be unreasonable to refuse a request for holiday when you know that they're going to be off for twice as long as they what effectively want to go off.
Okay, moving on to returning to work. Thank you very much so far, Paul. Steve, a new type of payment that I've not heard of before the last couple of weeks, hero payments. What considerations are needed when making hero payments, which are where staff are rewarded for coming into work? And are there any risks associated for the employer?
Yes, I must admit, Helen, this isn't a term I've come across before, a payment that I've come across before either, to be honest with you. It seems a nice idea. It's obviously a reaction to what is happening in the current coronavirus crisis. Essentially, what I think it is a bonus for staff that are still going to work, maybe working additional hours and things like that. So on the surface, seems harmless, seems like a nice idea, and might certainly incentivize certain staff to go the extra mile as a bonus under ordinary circumstances would. But I think there are potential risks, which I think was the second part of your question, which employers do need to weigh up and to bear in mind. I think they must ensure that they don't unintentionally discriminate against certain employees. For example, if you have a mix of sort of male and female staff, that it's not all the male staff that are getting the hero payments. I think staff morale is something to bear in mind as well. I think employees that are sitting at home, perhaps on furlough, or other employees that are working and aren't getting the benefit of these so-called hero payments, they're not going to be very happy about that. So that's going to have a potentially a detrimental impact on staff morale. It could lead to grievances, and in the worst case scenario, it could lead to claims. So I think, yes, sounds like a nice idea, might work very well for your business, but just be careful and weigh up the risks before you decide to roll that particular scheme out.
Yeah, I think from a PR point of view, it could potentially be interpreted both ways. It could be a great look at this great employer rewarding these brave staff, but it could also be twisted to say, is this employer paying people to sort of risk their health and risk their lives, and is that the right thing to be doing? So yeah, we do need to be conscious of sort of striking that right balance.
Yeah.
Great, thank you. Returning to work then, ending furlough, Paul, do we have to give notice for people to return from furlough?
Well, yeah, hopefully this will not go on forever and we can go back to work and get our staff back. In terms of notice, obviously, the Prime Minister did his broadcast at, I think it was 8 o'clock on the Sunday night, and said that now people should be encouraged to go to work where they can and where it's safe. There were some horror stories on Twitter of bosses demanding employees to come to work the next morning with no prior notice and no arrangements. There is no specific notice in terms of asking people to come back to work. Some people may be sitting at home desperate to get to work. Some people may have, as we've said, vulnerable family members, be vulnerable themselves, have childcare problems, and actually it might take them a couple of days to actually get sorted. So I think really all I can say is try and be as reasonable as you can in terms of encouraging, of asking them to come back or telling them when they come back. Obviously, it is up to the business as to when they need them back, and they can make that call. But I think realistically, it's going to be much better for everybody if you sort of agree something amicably rather than demanding they're back in at 9 o'clock tomorrow morning. Yeah, I think that's all you can do really.
What if an employee's been put on furlough, but then one of their colleagues gets sick and they are suddenly required to that?
Yeah, again, I mean, that's something that may have to happen. It's all to do with being reasonable with the staff member. I think if it's an unexpected circumstance and you do need someone urgent, well, if there's a group of people, it may be that you could ask, who would be willing, and then choose the person that's appropriate. But yeah, again, it's just about being reasonable, and I don't see any problem. Of course, provided that they have had 3 weeks furlough. So if it was only after 2 weeks furlough and you brought them back too early, it would potentially prevent the ability to claim back the 80%, because you've got to be off for 3 weeks.
Thank you. Steve, what about if an employee refuses to return to work when the business starts running again because they say it's unsafe?
Yeah, I think the first thing to do is for the employer to listen to the employee's concerns very carefully, and to take whatever concerns they might have on board. And as part of that process, maybe make any adjustments that they can to give the employee the assurance that their health and safety, will be looked after. Obviously, there is a general duty on an employer to protect the health and safety of employees, and that's important. If an employee raises genuine health and safety concerns, that could also be classed as what we call a protected disclosure. And if an employee makes a protected disclosure, they must not be treated detrimentally because of that, and certainly must not be dismissed because of that, because that could fall foul of whistleblowing provisions and lead to a claim of automatic unfair dismissal. So it is something that employers need to take seriously and listen to their employees. Employers should make every possible attempt to allow the employee to work from home. If that's not possible, they must make every effort to comply with government guidance on things like social distancing. They could also consider mitigating factors, perhaps introducing PPE, personal protective equipment, into the workplace, or perhaps face masks and things like that. But I think the important thing is to ensure for the employer to ensure the employee that health and safety is paramount, and that the employer has taken steps to mitigate the risk of any health and safety issues. There is also the option of the employee requesting holiday and taking a period of holiday, or even, I think, unpaid leave as well. Ultimately, if after a careful risk assessment and dialogue with the employee, you are certain that it is safe for the employee to return to work, it is possible to commence disciplinary action if the employee refuses to return to work, which is obviously a part of the contract that the employee must do whatever work the employer gives to them. But I think that would be a sort of last case scenario, really, and try to understand what the employee's concerns are in the first instance, I think.
And then considerations are around mental health. Is there anything that we should be thinking about in that?
Yeah, well, again, the duty to look after an employee's health also applies to an employee's mental health as well. I think it's important to point out that there are issues under the Equality Act, because if an employee has a mental impairment which has a substantial and adverse effect upon their ability to carry out normal day-to-day activities, then the employer also has a duty, firstly, not to discriminate against that employee, to treat them less favourably, but also to consider making any reasonable adjustments as well.
Okay, thank you.
Consideration, yeah.
Paul, bringing people back from furlough, discrimination issues, how do you pick fairly who you should bring back?
Yeah, I mean, this is quite a tricky one. Obviously, initially we're dealing with people potentially being unhappy that they were being furloughed. Now we're looking at potentially being happy that they're being brought back. As I said, most employees have been okay about it. We have had a couple of unhappy ones, shall we say, that we've had to deal with, but most have accepted the situation. But in terms of coming back, we're really much in the way that it was drastic times and quickly deciding how we were going to run as a business under coronavirus and how we were going to take advantage of the scheme, that we had to make hard business decisions. In the same way, I think it will be the same, literally, who is the best person for the job, and, can we get them back ASAP, because we need them. I don't see anything wrong with that, and I think really employees will have to accept that that's the position. There has been some grumblings, shall we say, but for staff who weren't furloughed, who had to take a pay cut whilst the person who sits next to them was furloughed. There was a bit of discontentment there, and that's, I think, why we've seen the hero payments and things like that, or potentially topping up or going back to full pay. Excuse me. But discrimination is really important here. Don't just assume that because someone might be vulnerable and or has a disability, that they should be not considered to be brought back. You really need to make sure that everybody is treated fairly and equally. Now, if you have got a disabled employee, now it may be as easy as a phone call to that person saying, look, we're looking at bringing people back. Are you comfortable with being brought back? do you want to come back? And if they say no, I'd rather stay on furlough, well, fine. But if they want to come back as much as anybody else does, then obviously you need to make sure that you don't discriminate against them. So it's really important that you treat people fairly and consider the Equality Act when bringing people back.
Thank you. Steve, looking forward, following the Chancellor's announcements last Tuesday, what's going to happen after July when the current scheme ends? Will there be any additional support?
Yes, well, what we do now know is that the scheme is being extended until the end of October, and there will be no changes, at least until after the end of July. Now, from the 1st of August onwards, the government has said that there will be changes made to the scheme to allow more flexibility, and we're not entirely sure as to what that further flexibility will be, or the full extent of what that further flexibility will be. We do know that furloughed workers will be permitted to work part-time, and we also know that employers will be asked to share the costs of furloughed wages. We don't know how much. There has been speculation online, but I must admit I don't know where the source has come from, where HMRC are currently paying 80%. This might be reduced to 60%. Now, we're updating our website on a continuous basis, and as soon as we receive any further announcements as to these changes, we will update our website, and therefore would encourage all of you to check our website on a regular basis to make sure that you're up to date with current announcements.
Great, thank you. And one final question on the employment side for Paul. Due to the lockdown, has the time limit to submit claims to the Employment Tribunal been extended?
No. Many of you will be relieved to know. There is a proposal that was happening anyway to extend that period to bring claim to 6 months. But currently, no, we're still at 3 months, and long may that continue, in my view. In terms, briefly, just to touch upon the Employment Tribunal itself, Steve, Michael and I, the rest of the team, regularly deal with employment tribunals for both employees and employers, and effectively pretty much all on stop. We did have hearings that were listed in person. Effectively anything that's happened in person, i.e. meaning the parties have to go to the tribunal itself, will have basically been postponed. They've been relisted. The earliest one I've had is for September. The delays were significant anyway. So to give you an idea, I was in February this year, I had a 5-day hearing listed for March next year for a disability discrimination claim. So we were looking at over 12 months in February, and that was before coronavirus. So the fact we've now had a full month of potential closure, potentially, it's going to be even longer. So anyone defending a disability discrimination claim, it will be a long time before the claimant gets a final hearing. So from a tactical and potentially cash flow point of view, if you think of settling the claim, and potentially it's one to sit tight on at the moment. Telephone hearings, some have gone ahead, some have been adjourned. For those of you who do know how the Employment Tribunal works, any sort of claims for discrimination will involve an initial preliminary hearing with the judge and usually the solicitor for the other side. And it's basically a meeting to have to make a plan for the case and to iron out any issues that need to be addressed initially. If the parties are represented, they will usually be done over the telephone now. So they can still go ahead, but I haven't had one yet. So I don't know. I have had a barrister friend of me having his son come into the door asking for a game of football in the garden whilst he was doing an application in the High Court on Skype. So there are practical disadvantages, but yeah, I think basically not a lot is happening at the Employment Tribunal at the moment, but hopefully we'll be back up and running soon.
Yeah. Brilliant. Thanks for that, Paul and Steve. I've got a few questions now for Victoria from our family team. We've got some scenarios which are fictional to put to Victoria that may have relevance to some of you listening today. So first one, Vicky, my ex-partner and I are separated, although the children spend regular time in the weekends. We've been discussing what to do with the children if the schools reopen next month and we can't agree whether to send them to school or not. How do we decide who gets to make the decision?
Afternoon, everyone. Yeah, so this is a really relevant question at the moment, and it's one that we're getting raised in lots of cases, in lots of different scenarios. There's obviously a general debate that's going on as well at the minute as to whether parents want to send their children back to school at all. That might be an argument that people could be having whether they're separated or they're actually still together, because parents might often have a different viewpoint on whether that should be, what should be the answer to that in any event. It really is going to depend on the kind of wider impact that the two families might be living in. So, for example, whether there's any vulnerable people, adults or children in other households, whether those parents are going out to work, and the implications that that might have on either whether they need the childcare, which feeds into what's been raised there with our employment questions, or whether that's going to have an impact on the safety of the children going. So it's often going to come down to an issue of parental responsibility. And generally, if parents are sharing parental responsibility for the children, then they're under an obligation really to try and reach a compromise. That would be the same with any other parental decisions. So there's two arguments, two sides of this really. One side is that the starting point is that the government is saying that children should be going back to school, certainly for the year groups that they're suggesting initially. And there's an argument then to say that if there isn't really a valid reason as to why the children shouldn't go to school, that you should really be following that government advice. But on the other side of it, we know that parents do have a choice about whether they send the children back to school at this stage. And that means that it could well be justified that they don't send them. And we know as well that they're not going to be issuing fines for children that are not sent to school. So there is still this element of compromise. I think ultimately, as with most sort of family law issues, they will generally come down to the specific issues that are going on in that case. But it's likely to be decided by the parent that has the majority share of the childcare. So if one parent is generally looking after the child for the majority of the time, it's likely that their choice as to whether they go or not is probably going to be followed.
Thank you. Another question on, or a scenario around blended families, pertinent to many of us. We're a family of four for 90% of the time, myself, my daughter from my previous marriage, my partner and our son. Every other weekend we become a blended family when my three teenage stepchildren come to stay. My daughter goes to stay at her dad's on that same weekend. I'm mindful and concerned that four of our children are spending time across three different addresses, with each coming into contact with additional step adults at each address, who also have an additional home address, and some of the people in those addresses are key workers and therefore going out to work.
Yeah, so again, this is a difficult situation that I think lots of families are finding themselves in at the moment. So we know that the government advice is that under the current restrictions, any movement between households for children going to visit one parent or another is not going to be a breach of those restrictions, so you're allowed to do it. It doesn't necessarily mean you have to do it, whether there's a court order in place or there isn't, because again, we know that the different circumstances people find themselves in, vulnerable people, etc., that can have an effect. So really what we'll be looking for is a common sense approach to be applied here. So if you're happy for the arrangement to continue and the children to come into contact with both families, that's absolutely fine. But there might be circumstances that you feel there's going to be an increased risk of cross-infection, as here where there are potential key workers in those other families. They might be working in hospitals. You might feel that has a wider detrimental impact. Perhaps if the children have got any health conditions or concerns, that type of thing, then you really can consider suspending that direct contact at the present time and doing something different. So thinking about implementing FaceTime, Skype, Zoom, that kind of contact instead, if that's felt to be safer.
One last one, Vicky. Another children-related one. I have four children who have a minimal one night a week contact with their father, which is his choice. I'm not particularly keen they go at all, as he will not communicate what his situation is in his household regarding what measures they're taking for social distancing, whether his new partner is still working, etc. He won't even clarify if, following a period of self-isolation for himself, whether he believed he had or was exposed to coronavirus. This appears reckless and irresponsible, as surely I should be made aware to enable me to be vigilant. In addition to this, the kids and I are now self-isolating due to symptoms, but he says the normal rules of everyone staying at home for 14 days don't apply to moving between households. How do I manage this?
Yeah, so this is another difficult one that I'm sure is coming up in households all over the country. So it's clear that if anybody in a household is displaying any symptoms, then they must self-isolate. So you've got to suspend contact in those circumstances, and that would kind of override the general principle that the contact arrangements would usually still be continuing. Again, we would look to say that the first port of call is to really try and agree things between parents. That's always the best way. Often we get involved when people aren't agreeing. So in this case, as the parent who thinks that children should be self-isolating, you can then exercise your parental responsibility and suspend that contact anyway. That would be the case whether there's a court order in place or it's just something that's simply by agreement. And I think here the parent needs to just be assured really that if you suspend contact in these circumstances, and if it ultimately was ever to come back before the court, so either for an enforcement of an order that's in place or maybe a new application that the other parent's made to say this contact should have been happening, then the court's really likely to be satisfied that you've acted totally reasonably in the circumstances. And again, it's just always worth remembering that there are other avenues of contact. So you might suspend direct contact, but you might still make sure that they can FaceTime, phone calls, that type of thing, if it's going to be appropriate for the children, depending on their age, of course.
Great, thanks very much, Victoria. Okay, that's all the questions that we have. I think the ones that have popped up in the chat have been dealt with by Michael. If there's anything else that anybody wants to ask in the last couple of minutes, then now's your chance. Otherwise, back to you, Louis.
Yeah. Well, yeah, thank you very much, everybody, for joining. I hope you found it helpful. I think Louis is going to send our details, and if you got any specific questions or you want to clarify anything, by all means, we're all here for that. So just drop us an email if you've got any questions. Thanks again. Cheers.
That's and just
Thank you very much, everybody.
Yeah, I'll send an email out following this event, just so you've got the contact details for everyone that's spoken today, and the recording link if anyone needs to watch it back. And look out for the future Chamber at Home events. Thanks very much. Bye-bye.
Thanks, everyone.